Good morning, everyone. Happy Friday. I would like to introduce you to Ms. Therese Yanan of the Native American Disability Law Center. I'm going to have her introduce everyone else today. We are recording this session so that we can have it available for later playback. I would ask that go ahead and put your questions in the chat and I'll help monitor the chat. And I think, Therese, you're going to do the questions toward the end.
Yes. Yep.
Okay, awesome. And I just asked that unless and until the host asks, if you can just stay on mute, since we are recording and background noise will be reported for posterity. And other than that, Therese, I'm going to go ahead and turn it over to you. Thank you, everyone.
Good morning, everyone. As Twyla said, I'm Therese Yanan with the Native American Disability Law Center. We have several excellent presenters to go over the New Mexico Indian Family Protection Act today. This will be a general overview of IFPA, and we will distribute the presentation after this session. I have planned 2 more in-depth sessions, one next Thursday on June 23rd, which will cover active efforts and placement, and then another one on June 30th that will focus on working with tribes and Pueblos and the qualified expert witness provisions. One of the things that we think is important is that this is a new statute, so we'll be focusing on the background and its relationship with the Indian Child Welfare Act, and trying to really emphasize the differences between the federal statute and the state statute. If you have any questions as we're going through the presentation, please feel free to put them in the chat. And as Twyla said, she and I will be monitoring that so that we can have some questions as we go along so that we make sure that we don't miss anything that you might be particularly interested in. And then at the end, we'll have time for more in-depth discussion or questions if we have enough time, that sort of thing. So I'm going to pass the time over to Christy Chapman so she can introduce herself. All the presenters will introduce themselves as we go forward, and then we'll get started. Christy, please.
All right, good morning. Thank you. Thank you, everyone. Christy Chapman. I am from the Pueblo of Zuni, and I am of the Eagle clan on my mother's side and Turkey clan on my father's side. And we really want to thank AOC and the other presenters here today. Before diving into sharing about the new law of IFPA, I have to start where we're always taught to start. And next slide, please. And that is with grounding ourselves from where we come from. I always start off in any presentation, whether it's on IFPA or what have you, start with these 2 individuals. These 2 individuals on my left and on my right is my great-grandfather, Bawikati, and on my right is my great-grandmother, Tsaisihtita. And from these 2 and from generations before them, these things have been shared down and passed down to us. And from these 2, what we call in the community where I'm from is from Zuni, is we call this Hotnawan Haitoshnan, our ways, our laws, our core values. Ubawikati and Tsaisihtita, we learned to always put family first, putting and making sure that we nurture our young and medicinally sharing with us our language. Language is powerful and it's sacred and it carries a lot of meaning. With that, they also taught us the rule of respect, to respect one another, to respect our elders, to respect our young ones, to respect everyone. They also shared with us their wisdom, and with that, that has been carried down to all their children, to me, my children, my grandchildren. And one thing that I really have to emphasize is that what we learned from our great-grandparents is the sovereignty. Sovereignty really does begin at home, and for our indigenous communities, sovereignty predates anything prior to contact. really want to hone in on what it means to be an Indigenous individual. Next slide, please. Why we really want to share and lay down the foundations for why ICWA and why IFPA. This is a unfortunate, I don't like to say unfortunate, but this is the reality for us as Indigenous people here in the United States. Federal policies beginning before the 1800s, but really the practice of removing us Indigenous people from our place where we were placed was really began in the 1830s under President Jackson. That was the removal era. Continuing on as expansion was going westward, putting Indigenous communities from the East Coast to the present, placing them onto reservations that took place in the 1840s. And even more sinister was also placing our children into boarding schools. And it's not a happy history to talk about, but it really lays the foundation on, again, why ICWA and why IFPA. After the boarding school era, there was the era of the Indian Adoption Project, where our Native kids were literally just taken from families without any notice to any families or any reason why. Reasons why that we know of is when they saw us as Indigenous people and the way we lived, it didn't meet the American ideals as far as a home. For us as Indigenous people, our land is our home. Whether we have beds or not, we share a home, we share space, and what's more important than anything of material value is family and community. So moving from that era of the Indian Adoption Project came the Indian Child Welfare Act, which was really to correct the wrongs of what had happened in the past of those forced removals of our children. Next slide, please.
Christy,
Yes.
this is Kip Bobroff, and I just want to add something to your slide if I could. I'm the in-house attorney for the Pueblo of Laguna, and I've always thought of myself as reasonably educated about ICWA. And I recently read the history of the Indian Adoption Project. And for folks who don't know that, that was essentially the BIA paying states and private adoption agencies for placing children outside their native communities. And under the Indian Adoption Project, those agencies got more money if they placed children with white families. And when I learned that particular detail, I was just blown away.
Indeed.
Thank you.
Indeed, that's so true. Going on, I can't stress enough that, we live in what we call a free country. I'm not trying to dwell on the past, but want to move forward in terms of making sure that the history as Native and Indigenous people here in New Mexico and the United States, there was that policy taking root over several hundred years to really remove us. And the saying was, kill the Indian, save the man. And that concept or that thought was really integrating us and assimilating us into just overall the American way, Western way, accepting all those ideals. And just recently, I bring up this policies that have been, again, found in a recent report that was conducted by Secretary of Indian Affairs, Secretary of the Interior, excuse me, Deb Holland, where they commissioned this study on the boarding school initiative. And again, this report just came out in May of 2022, and the findings indicated as indigenous people that we know, that federal records do indicate that the United States viewed official disruption to the Indian family unit as a part of the federal Indian policy to assimilate Indian children. What I love about this quote or this message here is that the love of home and the warm reciprocal affection existing between parents and children are among the strongest characteristics of Indian nature. Yet that was the exact policy, federal policies that were wished to be undermined. Next slide, please. Again, I gotta share this because a lot of folks don't know about our indigenous history. They challenge ICWA, they may challenge IFPA, but these are the reasons why we want to protect ICWA and IFPA. And again, the longstanding policies sought to absorb us into just the general overall population. When I think back of my grandparents, my great-grandparents, those things that they shared with us and continue to share with all of us is always look after one another. Never was there a point where we should let ourselves go, let our children go. Next slide, please. So with that, with all the policies in place from the boarding schools to the Indian Adoption Act, Congress knew that they needed to correct those wrongs. And so I'm looking at an audience of 38. I presented not too long ago to Santa Fe Indian School. So there was about 300 individuals, students in the class. And I told them to look around one another. And I said, just imagine if a third of you were taken from your homes for no reason at all. Well, it was a reality for us as Indigenous people in the United States. So if we imagine a fourth of Caucasian children removed from their homes for no other reason than, really no other reason, that was the unfortunate reality for us as Indigenous people. That being said, the reasoning I guess I say would be there was a lack of knowledge of our Indigenous culture, our child rearing practices, and those attitudes of not knowing who we are as Indigenous people gave state officials that unwarranted reason for removing our kids simply for being Native, being Indigenous, and appearing poor. Today, or well, in 1978, again, about 25 to 35% of all Native American children that were removed from their homes were placed outside, or were removed, and those that were placed, 85% of those individual children were placed in families who were not from their community. Today, we still unfortunately see the negative placement and taking of children. When I say taking, I say our Native American kids are 3 times more likely to be removed by state child welfare systems than non-Native kids. And of those, 56% of adopted Native kids are usually placed outside their families and communities. I can't stress enough again, for me in Zuni in general, we are told never to let our children go, to always hold them close and hold them tight. With that, why we need ICWA, why we need the Indian Family Protection Act. Here, I will just briefly share with you why we need ICWA. Right now, ICWA, which is the federal law, it's been attacked since it was created. It's been attacked because one, they feel, opponents of ICWA feel that it's a law that is racially based, and as Indigenous people, we know that prior to the Constitution, we were here, and as such, within the state of New Mexico, I just want to speak to the state of New Mexico. When we were under Spanish rule, then when Mexico came in, Mexico made a treaty with the United States to view us as Pueblo people, as citizens citizens from Spaniards to Mexicans, to Mexico, to the United States. From there, we were citizens of our communities, and as such, we have that political status as Indian people. I would like to just share that because ICWA is under attack, saying that it's racially based, that it's a law that discriminates based on race. Proponents of ICWA, we argue that we are not a race, we are a political, we have political status as Indians. I would like to share this time with Kip Bobroff to add in, just to give a little background as well as to the timeline of IFPA.
So thank you, Christy. Before we do that, Tracy, would you like to introduce yourself? And then I'll present this next slide on the background and development of Indian Family Protection Act.
Sure. Good morning, everybody. My name is Tracy Zamora. I'm from the and raised with the Pueblo Laguna. My clans are Big Parrot, Little Corn. As you know, the big portion comes from our father, or actually our mother's side, and the little side comes from our father's side. So Big Parrot, Little Corn. I come from the Silva Riley family. I have 5 children who are half Laguna and half Hispanic. So, you know, it's something new and, you know, very informative to teach my children both, you know, the traditions and culture of Laguna and Hispanic. But again, I just want to welcome you all to our presentation. Thank you.
Okay, I guess.
Thank you, Christy. So as background for the Indian Family Protection Act, as Christy mentioned, ICWA has been under attack more or less since its inception. But there was an initial important Supreme Court recognition of it in the Mississippi Choctaw versus Holyfield. And it's gone to the Supreme Court twice more. There's been this awful decision for tribal interests in adoptive couple versus baby girl. And there's now the case of Brackeen versus Holland, which is it's being briefed at the Supreme Court now. They granted cert. And as Christy mentioned, there is the equal protection claim there where well-organized forces are challenging the notion that Indian is a political status, not a racial status, and seek to overturn it on that basis. And then in addition, there's a 10th Amendment argument that the Indian Child Welfare Act is beyond the powers of Congress as commandeering of state resources. There's an excellent podcast, if you're interested in the background on this case, called This Land, that I highly recommend because it really gets into the guts and some of the insidious things that are behind this challenge. But with that said, as early as 2015, the tribes and the ICWA workers for the tribes, the ICWA liaisons, who are organized as the New Mexico Tribal ICWA Coalition, really began discussing the need for a state ICWA. And you can understand the obvious purpose of a state ICWA is that it defeats the 10th Amendment challenge. And then one of the changes of IFPA is that it narrows the definition and focuses it on even more on political status. So the tribes and INTIC were talking and discussing the need and working on the idea of a state ICWA going back to 2015. In 2020, drafting began on the New Mexico State ICWA legislation. That was one of the provisions of the settlement in Cavaness, and it fit with what the tribes and INTIC were trying to do. CYFD had a formal consultation, and after 2 different sessions and lots and hours of work, the Indian Family Protection Act was passed and signed by Governor Lujan Grisham in 2022, earlier this year. Next slide, please. So I want to emphasize a couple of things about both ICWA and IFPA from sort of the 30,000 feet. We all know about the best interests of the child standard. And what ICWA did first, and IFPA is in the same spirit, is it modified the standard of best interests of the child explicitly to include the child's relationship to their tribe. And so you can see that quote there, which is from the New Mexico Supreme Court, but it's quoting Mississippi Band of Choctaw Indians. And it talks about the same kind of dynamic that Christy described in the boarding school area and the removal of Indian children from their cultures and their identities. Next slide, please. I found this quote, one of the, to disagree with Christy just slightly, I don't give Congress much credit for recognizing. There was a whole lot of organizing behind that. And this is a statement that came out of the American Indian Policy Review Commission, which was led by Sam Deloria and a lot of other people through that worked on it in the 70s. But it talked about the damage that removing Indian children did to an Indian child. And I've experienced that in my family, and it's profound. The conclusion, which is not part of the report, the conclusion seems justified that ICWA is based on the fundamental assumption that it is in the child's best interest that its relationship to the tribe be protected. Next slide, please. And in addition, ICWA and IFPA even expands this further, added the Indian child's tribe as a party whose rights must be respected. So the Indian child's best interests or understood in terms of protecting its relationship to the tribe, but the tribe's relationship to its children and the tribe's right to have those children within their society and their community is also protected. Now, you'll notice that I haven't used the word culture yet. I think that one of the things that often is misunderstood about ICWA is the idea that it protects a child's right to have information and understanding about the culture. That's true, but that understanding and knowledge is not just the transmission of information. It really only happens in the context of relationships. I get really tired of hearing discussions about when there's a Pueblo child or a Native child who's placed with a non-Indian resource family. And there's always a question, well, where can we get information, videos, links? Can the tribe help us with that? And yeah, sure, that's important, it matters. But what really matters is creating and space for even children, for children throughout the system and even before they go into the system, to make sure they're living with and being cared for by people who are a part of their native culture, their tribal culture. Thank you. And I will pass it now. Back to Christy.
Before we go there, we do have a question regarding best interest. The question is if and how movement toward direct representation model in New Mexico will impact this best interest understanding. Christy, as someone who's worked as both a GAL and a youth attorney, would you like to address that?
Yes. So I think one of the key things that having the direct representation of a child, I can only speak to as a guardian ad litem. You have a kid that perhaps didn't grow up on the community on a tribal, with their tribe, yet they don't know about it because unfortunately all the federal policies put together result in this kind of situation, I guess you would say. How do I represent the best interest of a child while directly representing their interest? One, with ICWA and IFPA now really puts that relationship of the tribe to keep with that child. This is probably something that is not easily understood by non-natives, but in general, I can only speak for my tribe, but this is another conversation we should have, but children are really prayed for. Children are prayed for, and they are wanted, and they're valued, and they want them to remain within the community. And so knowing that as a tribe, they never want to lose their kids, they never want to see anyone go. It's always that understanding that I, as a GAL, work to balance. That means talking with the tribes, talking with the parents, getting just a history, getting a level of understanding of why wouldn't they want their child to be a part of their community. Learning how and digging a little deeper which does require a little more time, but learning why on the parent side and on the child side and the tribe side, the importance of why this child is sacred to its tribe. It's really a shift from what we've been doing in terms of, is it safe for a child to be with their extended family? If we're just looking at extended family, we're not considering the tribe as a whole as the family. I don't know if that will answer your question, but I think the importance of having that child have that relationship with the tribe is really important. If anybody else of the panelists wants to expand on that, please also provide your input, and Tracy, perhaps you can speak to that as well. But I hope I was able to answer that question.
Yes, and going back to how important our children are, you know, growing up with the Pueblo of Laguna, we're taught that our children are our leaders, you know, they're our future. They're the ones that are going to carry on our language, our culture, our tradition, you know, so it is a big thing, you know, when our children are brought back home. I just wanted to stress on that. Thank you, Christy.
Thank you, Christy, and thank you, Tracy. The Law Center has had a contract to provide guardian ad litem services and youth attorney services in the 11th District for over 10 years now. I'm not Native, I'm not a member of a Native community, but I've really had the pleasure of working with so many wonderful people like Christy and Tracy and members of the Navajo Nation. And I think as a guardian ad litem, this goes directly to the direct representation model of children, in that, you know, even if a young child, even if a toddler cannot express his or her interest in being a member of his or her community or his or her tribe, I think as a guardian ad litem, it is part of our obligation to look out for their best interest. If we go to the direct representation model, that if we're building their relationship with the tribe or the Pueblo of which they're a member, then they can decide as they grow older what that relationship is. But I think it is part and parcel of the direct representation model personally that we support that that relationship to the best ability that we can. I don't know, Deb, if you want to add anything, or if that addresses your question, we can take you off mute if you'd like. I think it's an important issue to raise.
Thank you, Therese.
Okay, thanks, Deb. Tracy, did you want to speak to for the communities here in New Mexico a little bit more directly?
Sure. So the slide we have on now is just a slight representation of our original inhabitants here in New Mexico. Again, this is the communities that we have, or the tribes and nations we have here in New Mexico. This is the original inhabitants, but today we have 23, which is the Zuni, the Navajo, the Pueblos along the Rio Grande, the Mescalero Apache, and the Jicarilla Apaches. What was once land occupied by our indigenous peoples is now, as we see it, that land base is a little smaller now. However, regardless of what a map shows us today, as indigenous people, we know the areas of the state. We know not only in New Mexico, but Arizona, Colorado, Utah, the areas that our ancestors had occupied. Today, we see again the sovereign nations within this land. Again, the Pueblos along the Rio Grande, Zuni, Yakima, Laguna, the Navajo Nation, Jicarilla up north, and Mescalero down south, and the You can't see the screen, but you get a picture of the tribes, how many tribes we have in the state of New Mexico, and that doesn't include the children who are in the system that are across the United States. Next slide, please.
Okay, hi everyone. My name is Austin Moore. I'm gonna be moving on to a little bit of the boring pieces, just getting the textual pieces of the ICWA. Just to introduce myself, Ait Squichil, Austin Moore Tsenesna. My name is Austin Moore. I'm a member of the Samish Indian Nation with ties to the Little Shell Chippewa tribe on my mother's side. I grew up in Yuma, Arizona, next to the Quechan and the Cocopah tribes. And I went to Michigan State for law school before joining the Law Center as an attorney in the Flagstaff, Arizona office. So to get started with the ICWA and the IFPA a little bit, I'm going to focus on one of the differences that you can see in the IFPA from the ICWA, and that's the definition of Indian child. So in the ICWA, there's two definitions that are important here. One is that an Indian means any person who's a member of an Indian tribe or who's an Alaska Native and a member of a regional corporation. And then the second is Indian child. And this means any unmarried person who is under age 18 and is either a member of an Indian tribe or eligible for membership in an Indian tribe and is the biological child of a member of an Indian tribe. So if you recall, as Kip was saying in the Brakim case, one of the big attacks on ICWA and legislation like the IFPA is that it unconstitutionally racially discriminates. So in the IFPA, there is a change that now says Indian means whether an adult or a child, a person who's a member of an Indian tribe or eligible for membership in a tribe. And then Indian child means a person or a person whom there is reason to know is an Indian person under age 18 who is neither married or emancipated. So the key difference here is that the difference in the ICWA and the IFPA definition for Indian child, that piece of the biological child of a member of an Indian tribe. So this gets rid of what's seen as a racial category rather than a status, the political status of Indian tribes and Indian people, as Christy was talking about. So now the IFPA, it turns the definition into something that's based solely on that political status. Another difference is that it also helps to include children that are eligible for membership, even if their parents aren't enrolled, as long as you're eligible for membership, you're considered an Indian child. For example, say neither of my parents are enrolled, but I'm eligible for enrollment. I would still be an Indian child under the IFPA. The focus is on the Indian child rather than parents. And in these cases, just as a practice point, the burden lands on the party that seeks to establish application of the ICWA. They have the burden of showing that the child is an Indian child. And then kind of a side piece, but an issue that sometimes comes up is what would give a court reason to know that an Indian child is involved. So the BIA actually has guidelines related to the ICWA, which includes that there's reason to know if any party to the case, tribe, Indian organization, agency informs the court that the child is an Indian child. Likewise, if any public or state agency involved in child protection has discovered information which might suggest that the child is an Indian child. If the child themselves give the court reason to believe that he or she is an Indian child, it might be the residence or domicile of the child, the biological parents, or the custodian, or if an officer of the court involved in the proceeding has knowledge. So next, I will hand it back to Christy to talk more about how membership is determined in these cases.
All right, thank you. So determination of a child's membership. Here, member or membership really means, gives that entitlement to the tribe. The tribe makes that determination that an individual is a member or is eligible for membership in that tribe. Austin pointed out that though both his parents aren't enrolled, it's not up to his parents or the courts. It really has to be up to the tribe. With that, as part of a department's active efforts, determination of a child's membership must occur at all proceedings. This is a change. Well, this is, really want to highlight that all proceedings within IFPA includes investigation and at custody, and just really throughout all stages of the proceedings. Again, I can't stress enough that there's no discretion given to a court on who's eligible for membership. That determination, again, belongs to the tribe. Next slide. Okay, this piece right here changes to, or the important definitions of child custody proceeding. I think I highlighted that is child custody proceeding means, again, an action for foster care placement. It also means termination of parental rights, permanent guardianship, or adoptive placement, or an action pursuant to the Indian, to the Children's Code 32A, 3A-8, or the Family in Need of Court-Ordered Services Act. Again, this includes investigations and other preliminary activities preceding the formal initiation of an action, but it doesn't include delinquency proceedings or custodial proceedings or kinship guardianships pursuant to Chapter 40 of the Children's of the NMSA. Here, the important definitions, again, is also the extended family member. Under IFPA, it means a person who is defined to be an extended family member by law or custom of an Indian child's tribe, or in the absence of such law or custom, a person who is over 18 or older and who is an Indian child's grandparent, aunt, uncle, brother, sister, brother-in-law, sister-in-law, niece, nephew, and so forth, first or second cousin. I'll tell you quite real quick, in Indian country, first, second cousin to us is irrelevant. Your mom's sister, your mom's cousins, they're your aunts, they're your uncles. And so I just want to share some of that as far as within Indian country, also those who are might be of the same clan, those are also would be considered extended family. Next slide, please.
Christy, we have a couple of questions regarding the membership. I'm sorry, I didn't see them before we started talking about the proceedings. One question is whether or not, with regard to membership, are there geographic boundaries?
No. So as far as membership, sorry, are there?
No, I like a succinct answer. That's good.
No, even recently, there was it's a state case in New Mexico. The family was from Arizona, and this happened prior to, actually at the custody hearing. There were family that were available and ready and willing to take the child, and the Navajo Nation, made that determination, and the child was moved. The case was dismissed. So geographic boundaries shouldn't be an issue. Families available, families willing to take the child in, family goes to the child. That's the heart of ICWA, to keep the child at the heart and center of their tribes, nations, and pueblos.
And
you can think of it the same as, oh, sorry, Tracy.
Sorry, go ahead, Austin, please.
I was just gonna say, you can think of it like state citizenship too, or national citizenship. You're a citizen of your country or your state, no matter where you're located. Membership goes with you.
Hmm. Yes.
And different tribes and pueblos define it differently. And so, but it is always ultimately up to the tribe to determine it. There's another question regarding, we had in the previous slide at every stage afterwards. And the question is that also including each judicial or permanency review?
Yes. Every stage means throughout the entire course of the case. So every stage means even investigations, which wasn't in ICWA, even before investigations, it means every stage.
And then there's another question regarding the New Mexico statute site for IFPA. Based on our last check, which I think was a couple of days ago, it hasn't been given a statutory site yet that we know of. I'm sorry, excuse me, for moving the slides. And so that's why in the slides we have reference to the section of the bill, which we can circulate a clean copy to everybody pending statutory, I don't know what it's called, but you know, incorporating it into the annotated statutes.
Right, real quick, Therese, I just posted it in the chat too, but the final bill is House Bill 135 of this past 2022 legislative session. I think they still have it on the New Mexico legislature website.
Okay, great. Thank you, Austin. And then there's another question regarding the definition. Can the definition of Indian include indigenous people of other countries?
Say that again.
Can the definition of Indian include indigenous people of other countries?
I
If we
think
go,
we go to the next slide.
well, if we, oh, I'm sorry. I went
Sorry.
back to the Indian definition.
Let me
So no ICP.
So I believe in ICWA, I don't have the section for the IFPA on me, but I believe the definition is a federally recognized tribe. For the definition of Indian, the definition you were just on, it would need to be a member of a federally recognized tribe, so generally not indigenous peoples from other countries. However, I think there's two cases like Tatnahatam and one of the tribes over in New York, they're actually split across the border. So I don't know if this is the right answer, but I assume if you are a member of a federally recognized tribe in the United States, even if you live across the border, you'd still be considered under the ICWA.
Do we go
Okay.
on?
Yeah, Christy, did you want to move on to the fictive kin?
Sure. So again, one of the highlights of the definitions, again, fictive kin does mean a person who isn't a relative or an extended family of an Indian child, but who has a significant family-like relationship with the child or the child's family. And that relationship existed prior to the child entering the system or into the foster care, and who also meets the definition of fictive kin as established by an Indian child's tribe, law, custom, or traditions, or is chosen by an Indian child who is 14 years of age or older, regardless of when the relationship between the person and the Indian child was established. when it is in the child's best interest to identify that person as fictive kin. I think here it's really important to note that you may have non-native family who, not by marriage or anything, who has been a part of an individual's life, a child's life, prior to the child going into foster care. If it's in the child's best interest to look at that individual as possible placement, and the child knows this individual, then that would include that individual as a fictive kin. Next slide, please. And that wasn't within ICWA prior to that language was not in ICWA, but it is now in IFPA.
We have another question, and it's clarifying that IFPA goes into effect as of July 1 in New Mexico, and essentially asks about the relationship between federal ICWA and the New Mexico IFPA. I think that, yes, Chester, as you say in the second half of your question, that the ICWA remains in effect. The courts still have to comply with ICWA, but is supplemented by IFPA. As Twyla says, the federal law sets the floor, but IFPA adds to it. So the provisions, and there are some provisions that are consistent with ICWA, and IFPA just sort of raises the level of coverage and practice. I don't know if anybody has something to add to that. Christy, Tracy, Austin?
No, I like it. The IFPA is the ceiling, and what Ms. Twyla noted is that ICWA's the floor and IFPA's the ceiling. If ICWA was considered the gold standard, where the folks are native social workers are saying IFPA is the platinum standard. So really taking a look at really protecting our, what we consider our sacred trust, our kids, making sure that they remain with family. Next slide.
Okay, I'll take this one. So here we're going to be talking about notice to the tribe, which is notice of the proceeding. So in a child custody proceeding, when the court knows or has reason to know that an Indian child is involved, the department shall notify the parent, guardian, or Indian custodian and the Indian child's tribe by certified mail with return receipt requested of the pending proceedings, the right of the Indian child's parent, guardian, Indian custodian, and Indian child's tribe to intervene and petition the court to transfer the proceeding to tribal court. Also, the right of the Indian child's parent, guardian, or Indian custodian to court-appointed counsel if the court determines that person is unable to afford counsel, and the right of the Indian child's tribe to participate in the child custody proceeding, whether or not the Indian child's tribe intervenes. So first, why is notice important? So SCOTUS, as Kip was talking about earlier in the Holyfield case, stated that Indian tribes have an interest which is distinct from, but on a parity with the interest of the parents. So notice ensures that the tribe has the opportunity to assert its rights and protect both the best interests of the tribe and the best interests of the child. So the burden of providing notice is on the party seeking foster care placement or termination of parental rights. So often this is the state agency, but in certain cases it can actually be the court or even the foster parents. So notice would go to each tribe in which the child is a member or eligible for membership. I think one of the things we didn't talk about earlier is that a child might be eligible for membership in multiple tribes, or might be a member in multiple tribes. Notice would go to each of those tribes. A child might have more than one tribe that has rights in a ICWA case or IFPA case. So the timing for notice, so notice is required within 24 hours of the filing of a petition, so in the investigative stage. And then foster care placement or TPR cannot be held until 10 days after receipt of that notice. Upon receiving notice, tribes can then request 20 days to prepare for the proceeding. Notice is also required at any child custody proceeding. So this would include notice of placement changes, notice of permanency and permanency review hearings, judicial review hearings, guardianship, temporary emergency removal, when the child is a resident of the reservation. And then notice of the tribe is required even in voluntary placement agreements.
I think here we have a question for the tribe. Why it's important for a tribe to get notice? And I posed this question for Tracy. What does a tribe do when they get notice?
So once, it's very important at the beginning stages after the notice, because we then verify enrollment status, whether the child's a member or the child's a descendant. In most cases, we sometimes find out the children or child has multiple, is not registered, but say there's a child is Laguna, Acoma, and Jemez. So we reach out, or we let CYFD or state, we notify them that the child is Laguna, Acoma, Jemez, so all the tribes can come together and, you know, we can decide what's in the best interest of the child. But not only that, we're able to see if the tribe can offer services to the family, to the parents, and start looking for family, you know, in case we do have to remove the children.
Thank you, Tracy, for that.
Tracy. On this slide, the only two pieces I wanted to talk about were specifically the intervention and the transfer pieces. So tribes have the right to intervene at any point in a child custody proceeding. And as I said earlier, any tribe that the child is a member or eligible for membership is permitted to intervene. And the tribe may also present and participate at closed hearings, even if they have not intervened. It may also examine reports and documents filed with the court that a decision may be based on. And then for transfer, so the way IFPA works is that Indian tribes have exclusive jurisdiction over Indian children who reside or domiciled within the reservation, or if the child is under the jurisdiction of the tribal court, so a ward. And then if the child is domiciled or resides off reservation, then jurisdiction is concurrent with the state court. So the way this works is at the beginning of the child custody proceeding, or if there's a motion to transfer, the department is required to ask whether the tribe is going to accept jurisdiction. But the right by the parent, guardian, custodian, and tribe to move or transfer can happen at any time during the proceeding. It doesn't have to be at the beginning. If the tribe accepts jurisdiction, the court shall transfer to tribal court unless either parent objects or there's good cause that exists to reject the transfer. And then lastly, in the case that an Indian child's tribe cannot be determined, for notice, notice will be given to the Secretary of the Interior, and then the Secretary will have 15 days to provide notice to the Indian tribe. I don't know if Tracy, you spoke about it a little bit, if you want to talk about specifically intervention and how powerful that is for the tribe to have the right to intervene. But you had talked about it earlier.
Yeah, so in most cases, the tribe will always intervene. The good thing is because I'm from the Pueblo Laguna, I know quite a bit of people. So, you know, when we get those notices, I automatically intervene. You know, just so we can follow from beginning to end, because, you know, ICWA cases move so fast. We want to be able to help the family, you know, before the situation gets you know, out of hand or gets worse. So intervention is a big part, you know, whether it's sitting down,
I'm sorry, Tracy, you're breaking up really significantly. I'm so sorry. Yeah, I apologize for the
family
audio
center
problem.
meeting, these barriers are there. Can you hear me?
Yeah, I'm sorry, you were breaking up really significantly there, Tracy.
Okay, I'm up
Sorry.
in Nambe, so the service isn't great here. What did you get? Do you want me to repeat the whole thing?
Yes.
Okay. Intervention is very important at the beginning of the case. Just the fact that we can help the family, you know, set up a family center meeting, whether we help them get services in place with the tribe or where they're located at. Sometimes they're not always on the reservation. They may be, you know, out of the reservation. We also have the Senate meeting to see what barriers are set for the family to help them overcome that. Not only that, but to help find family for who can be that who can assist the parents and the children.
Yeah, I think that I think that's a really important point, Tracy, and I think it's a real significant difference between IFPA and ICWA is the notice to the tribe before the filing of the case. I think we can all recognize, those of us who have worked in this area, as we all have, you know, we all recognize the trauma that is inflicted on children when they are taken out of their families, when they're taken away from their homes. And so if the notice, if the tribal services can be involved before the case is filed, before the child's taken into custody, I think it can provide you know, some significant assistance to the family, also ensuring that the family is both being treated in a culturally appropriate way, and also receiving culturally appropriate services to try and address the issues before the child's taken into custody. And as Tracy said, if the tribe, if the Pueblo can find family before the child's taken into custody, then even if the child, if CYFD feels that they need to file something, there's a huge difference between a child going to spend time with auntie and uncle versus going to a stranger. And so I think that, you know, that significant piece of providing notice to the tribe at the investigation stage hopefully can help prevent a lot of trauma and disruption that children have to experience. One of the things we were talking about when we were preparing for this was if or what remedy there is for failure to provide notice prior to filing the case. And that's somewhat, I think we came down on an open question. I don't know, Christy, you had some thoughts on that. So if the case is filed and CYFD hasn't provided proper notice to the tribe or Pueblo during the investigation stage, how do you think you would address that as a GAL or a youth attorney?
In our discussion on that topic, no notice was provided. The tribe could have had a family available, and without their input on a case, that I would argue that the child be placed with someone the tribe identifies, because a lot of times what happens is if tribes don't have notice, then the agency has no idea of knowing if there's family available. And so it's really important to provide notice to the tribe. I have been working with tribal social workers, and they are really quick to identify whether or not they have someone within their community or they know of individuals within an urban setting, tribal members within the urban setting that are willing and able to take in a child, whether or not they're family, but they are a part of the community. I think we can go to the next slide. Okay.
Sorry, just one more thing on there. Just looking around how some other jurisdictions have done it. So some courts have held that a failure to give proper notice renders the proceedings null and void. And then some appellate courts have remanded to correct the deficiency, and then leaves it to the lower courts to determine whether the error prejudiced the proceeding to invalidate. And then due process might also be violated by a failure to give proper notice. One of the interesting things, this is to membership, and whether a child is determined to be an Indian child. But in the cases of voluntary placement agreements, if a child is not determined to be an Indian child and is later determined to be an Indian child, that agreement is voided. So I think there's room to say, if notice isn't proper, that the child hasn't been identified as an Indian child, that would lead room for a proceeding to be invalidated.
Active efforts. Really want to highlight here that no longer can an agency find findings of futility or aggravated circumstances as a reason for placing a child with a non-family. So active efforts here have to be that affirmative, active, thorough, and timely that represent a higher standard than just reasonable efforts. I can't stress this enough in terms of how important it is for an agency to make those efforts, because one, when tribes are looking at a child being taken into custody, they don't want to repeat the past. They really are mindful of the past and what has happened to children, not only in New Mexico, but across the US. That is always front and center. No tribe wants to lose their children. And as Tracy has stated, our children are our future leaders. They are the carriers of our knowledge, of our culture, and for those reasons, that's another important reason why we really hold active efforts on the part of the department to make it affirmative, make it active. Again, the goal is to maintain or reunite that child with the child's family. Again, IFPA requires active efforts and no longer finding futility or aggravated circumstances as a reason to stop. Again, with that, you know, we're only touching on active efforts here, providing a generalized overview, but really crucial is identifying family and fictive kin as part of active efforts throughout the proceedings. Next slide, please.
So next, moving on to placement preferences. So there's two different sets in the IFPA of placement preference. One is for foster care placements, and the other one is for adoptive placements. So we're going to start with foster care here. So first, the child should be placed with extended family members. Second, in a foster home licensed, approved, or specified by the Indian Child's Tribe. And then third, a foster home licensed or approved by a licensing authority in New Mexico, and in which one or more of the licensed or approved foster parents is an Indian. So an important part of the IFPA here is that under no circumstances shall a child be placed that is under 3 months of age outside of these placement preferences provided in this section. And then importantly, these are the default placement preferences, but courts are required to abide by the placement preferences that are established by the Indian Child's Tribe. And then if the tribe does not have placement preferences, these are the ones that the court would use. Aside from the placement preferences, there's also requirements that a child be placed in the least restrictive setting that most closely approximates a family, taking into consideration the Indian child's sibling attachment. 2, allows the Indian child's special needs, if any, to be met. And then 3 is in a reasonable geographic proximity to the Indian child's home, except extended family members or siblings. So similar to non-ICWA cases as well. So these, yeah, sorry, go ahead.
Oh, I'm sorry, Austin, please, I didn't mean to interrupt. Please go ahead.
Oh, no, it's fine.
I think as a practitioner, I think one of the interesting things about this provision is that second point that requires the tribe approve the placement of a child under the age of 3 months. And so the way I read that anyway, and this is, you know, just my interpretation, is frequently when children that young are brought into care, sometimes they're just placed. The way I read this section, if the foster home has to be approved by the tribe, then it requires that the department, again, work closely with the tribe to find placement, to find hopefully family that will take that child that young into their home. So it kind of ties with that investigation piece and that close working relationship between the department and the tribe. And so that's the way I would read it as a GAL anyway. Go ahead, Christy, I'm sorry.
I wanted to go back to not only placement, but this goes back to active efforts. And I don't know if we still have Tracy on the line, but really wanted to provide some examples where active efforts weren't made, and why it's very important to include the tribe when it comes to active efforts in finding family. We often hear an agency using Seneca search. Seneca search is limited, the data could be old, but really contacting the tribe and inquiring from them who is related to this child and what they can do on their part to assist the agency in finding family. Another important thing that has been overlooked, but I think Austin stated earlier too, was asking the kid. I don't know how many times I've I don't want to say I'm astonished, but not asking a child who their family is overlooked by an agency. And just simply asking who they identify. With those wanted to share, I was hoping Tracy was on, but she could provide some more insight on the tribal side as far as active efforts and what that looks like. Pass it back on to Austin. Thank you.
Thanks, Christy. So I just wanted to highlight how the IFPA definition is different from the ICWA definition. So in ICWA, the first two bullets are pretty much the same, but the ICWA actually splits that bullet 3. There's a 3 and 4. So 3 being an Indian foster home licensed or approved by an authorized non-Indian licensing authority. And then there's a 4th one, which is an institution for children approved by an Indian tribe or operated by an Indian organization, which has a program suitable to meet the Indian child's needs. So the idea here is that this bullet number 3 in the IFPA takes the definition of an Indian foster home in the ICWA regulations. And then it also removes institutions as a preferred placement in the IFPA. So these are the placement preferences. If a child is placed contrary to placement preferences, then the department is required to conduct monitoring every 30 days to determine whether a preferred placement is available. The department's required to make active efforts to identify a preferred placement. And then the court shall hold hearings every 6 months. And the department must show good cause at these hearings for why a child is not in a preferred placement. And this is where, as Christy was talking about, in these good causes, it's that if the child is of a sufficient age and capacity to understand the decision that's being made, then the preference of the child can be taken into consideration as well to who they consider their family, where they want to be placed. So next, I don't know, did either of you have anything on foster care placements?
Oh, sorry.
Just before I move to adoptive placements. Okay, so for adoptive placements, these are a different set of preferences. So as we've talked before, this is one of those situations that it should be remedied once the IFPA is codified. But if you look for these placement preferences, adoptive placements, you're not going to find them, but they're in the Children's Code. So once the IFPA is codified into the Children's Code, then it'll all be together. But if you're referencing the IFPA pill, you won't find these. So anyways, so these are the same as ICWA, but what the IFPA adds are the cultural compacts here. So if the household into which an Indian child is placed for adoption or guardianship does not include a parent who's a member of the Indian child's tribe, then the court shall require the parties to the adoption to enter a cultural compact at the discretion of the Indian child's tribe that documents the parties' agreement regarding how the Indian child will continue to actively participate in the Indian child's cultural learning and activities and engagement with family members. So each cultural compact is to be specific to the Indian child and shall articulate the Indian child's understanding as the Indian child grows and matures. So the cultural compact will become part of the court record and shall be enforced by the court and shall be included in the adoption decree. So I don't know if you guys have seen what these look like yet. I haven't seen a cultural compact yet, but I'm pretty excited about them. It's pretty unique to New Mexico. And I think it'll definitely benefit the children who are unable to be placed in preferred placements. So even outside of preferred placements, they still have that connection to their tribe and to their family as well.
I just want to add on to that. I think this is really important in terms of when we've spoken to people who might have been placed in non-native families and not have that connection to their Indian tribe, there's that feeling of they know they're different from their non-native family, and yet they know that they're in a, what's the word, as far as identifying themselves, they don't belong quite particularly to the white world, nor do they feel like they belong to their tribe. And so there's that disconnect. And that's one thing we hear from folks we have spoken to who had been adopted out and not having that connection. They know that there's something missing from their life and they don't know what, when they learn that they are a part of a tribe, or they could have been a part of their tribe, but there was not that agreement in place. You know, once they're old enough, they tend to go back to the tribes that they come from and want to learn. But having compacts such as this not only solidifies, but continues that relationship, even though they can't be directly within the tribe. Maintaining those cultural ties is really important and crucial for that individual's identity. And it really goes back to reaffirming that, you know, they are a part of a tribe, and yet they're also have a family that they can be able to be with. And so I really, this piece, this cultural compact piece, is really important. And next slide.
So qualified expert witnesses. So again, we're going to be doing a training specifically on this topic in the upcoming weeks, but I'll give a little bit of background here. So qualified expert. So the court shall receive testimony from one or more qualified expert witnesses in all adjudicatory hearings pursuant to the Abuse and Neglect Act, and all hearings to terminate parental rights. So the court shall receive testimony from a qualified expert witness, regardless of whether the parties to the proceedings have stipulated to a finding of abuse or neglect. And this is different from the ICWA as well. If you guys want to talk more about how this piece is important.
Christy, do you have anything to add to that?
So for this piece, let's see. I think one thing here that adds that the language as far as the court shall receive testimony from a qualified expert witness, regardless of whether the parties have to the proceedings have stipulated to a finding of abuse or neglect. I hear it's, what's that? Sorry, was there an echo? Sorry. It's important to note, we were discussing this earlier, and I think Therese, you might be better able to share your experiences with the Navajo Nation, and but it's important to note that a QEW can be heard at any time. I think that's the takeaway from this, and whether or not the parties stipulate to it, it's important to note that this is a change, and I want to be able to have Therese expand on what the discussion we had earlier on this issue.
Sure. The Law Center does all of the represents children in all of the ICWA cases in San Juan County. So that's pretty much exclusively what we do here in San Juan County. And most of the cases that we have in McKinley County involve Native children. And so I just thought that this was kind of an interesting provision, because frequently, if up to this point anyway, if there was a stipulation or a no contest, then the court would go through their questions. I think this is kind of, from a practice standpoint, this will present sort of an interesting question, like does the expert witness, if there has to be testimony from the expert witness, regardless of any sort of stipulation or a no contest position by the parent, is that before or after the questions by the court? Does it matter? Is it an affirmation to the court that the tribe is supporting the position? I think it presents some really interesting questions that'll be that we're all just going to have to figure out as we go forward with this as a practice point. Obviously, I have zero concern about it in the sense that I think that up here in the 11th anyway, most of the children we represent are members of the Navajo Nation, and both the local CYFD office as well as our office, I think, has a very collaborative working relationship with the Navajo ICWA workers. I think the provision about the department specifically requesting in writing that the tribe designate a QEW also presents potentially some interesting points with regard to both respecting the tribe as far as having the tribe or the Pueblo specify who the qualified expert witness is, but also it's going to require, I think, that close working relationship between the local offices and the tribal and Pueblo ICWA offices. And so if that isn't already existing, I think that the sooner those relationships can be developed, the more, the easier it'll be to implement these provisions to make sure that the court has that, that testimony from the qualified expert witness as quickly as possible. I don't know if anybody has any other thoughts or comments about this. I think it'll be interesting to see how it plays out. Also in our up here in the 11th, especially in San Juan County, we usually stipulate to the qualifications of the qualified expert witness. So it's not very common that we have any sort of disagreement on who the qualified expert witness is. Again, I don't know how it works in other jurisdictions. Christy, have you seen that being an issue in the ICWA court in the second?
Can you repeat what your question was? I'm sorry.
The qualified expert witness, has there been any disputes over the qualifications of the qualified expert witness in ICWA court?
Unfortunately, yes. And it had to do with the ICWA requirement of the QEW being able to testify not only to the cultural standards or cultural standards of a cultural wise, but a qualified expert witness to testify also to the serious harm to a child. That has come up within the second judicial, and that can be a discussion when we discuss the qualified expert witness portion of the training coming up in June to dive deeper into that. I think that will be a very lively and discussion for that time. But
Will
yes,
present some interesting challenges for us all, I think.
yes.
Austin, did you have anything to add on the QEW?
Yeah, I just saw a question from Deb. Is the substance of QEW testimony the same as in ICWA? Yeah, so the role of the QEW is to testify on whether the child's continued custody by the parent, guardian, or custodian is likely to result in serious emotional or physical damage to the child. And then there's two burden of proof. So the burden of proof for the court to find for the serious emotional and physical damage is beyond a reasonable doubt for TPR, and then a clear and convincing standard of proof for foster care placement. But yeah, I think you guys covered it, and just how important QEWs, how important they are to ensuring that the culture and the traditions of the tribe are are heard and that they're not used as premises for removal.
And of course, the rules of evidence in Rule 11, 702 would still apply. So if that was the question that was posed, the rules would still apply.
Okay, there's also a question about whether the court needs to receive testimony from a qualified expert witness in a permanent guardianship hearing.
Trying to think in the IFPA. I don't think the IFPA sets out a separate, like it doesn't enumerate permanent guardianship hearings, but it does say all adjudicatory hearings and then TPR hearings.
And then IFPA requires the tribe or Pueblo to ID the QEW. It requires the department to request that the tribe designate the QEW. Deb, I'm not, Austin, I don't know if you recall the provisions if the tribe doesn't respond. I don't think that's addressed as I recall, but.
The IFPA sets, we can go more in detail in the QEW
Session.
In that session, but it does set up timelines. I think if one isn't identified in either 15 or 30 days, then CYFD will then have to ID one, but still must meet all the qualifications.
Yeah. We're going to leave everybody hanging so you come to the next session. Okay. Anything else on QEW, Christy or Austin?
Not at this time.
Okay. I don't know if anybody else has any other questions or comments. Twyla, if we can have, I don't know if people can take themselves off mute. Maybe we can have more of a free-flowing conversation if anybody's interested in that.
Yes, I didn't see any questions that hadn't been answered yet, but definitely either raise your hand or put it in chat.
Can you hear me?
Uh,
This is Dan Harnick.
Sure, Dan, go ahead. And Allison, right after Dan, we'll come to you, okay?
The one question that I have where it's come up down here is when we're talking about the ICWA expert, we've had people who are not experts in certain tribes try to be an expert for another tribe. And that's something that I haven't seen you guys address yet. And maybe I missed it because I got kicked off. Our internet went down for about 20 minutes. So, but has that been addressed? Because that's something that's come up down here. That's the only question we've had when we were, questioning an expert's expertise is, hey, look, you're an expert in one tribe, but this is not the same tribe. I'm not sure how you guys approach that.
We did not cover that specifically, Dan. I think that raises some really interesting challenges. And especially here in New Mexico where they've split what the expert can address, I think it presents some really interesting questions. There's not a requirement under ICWA that the individual be a member of the tribe, but just be able to speak to the child rearing practices. In our experience, it's usually a member of the tribe. Chrissy, I don't know if you'd like to address that.
For us in the second, it has been that expert witness who wasn't a member of the tribe, but the tribe utilized that QEW and a QEW that they had used not only in New Mexico, but in other states as well. That has been my experience in the second.
This is Nancy Simmons. The New Mexico Supreme Court is having an argument on that issue among several ICWA issues in July. We won a case in the Court of Appeals that the expert was not qualified to testify on several scores, that it was fine to keep the child removed. And the Supreme Court took cert.
Allison?
Yes, hi, thank you. My question was a jurisdictional one. Is there any provision in this new law that that explains how to, or that addresses how the court and all parties should manage a case in which there is exclusive jurisdiction for the tribe, but for a variety of reasons, the tribe has chosen not to assume jurisdiction, not to transfer it. They want the child to stay in state custody. I ask, I've had a few cases where that's been the case, primarily due to lack of resources, and that is why the court made a finding that the child or children had their domicile was on the reservation, and therefore it would be exclusive jurisdiction for the tribe. And the tribe said, no, we want the child to stay in state custody due to lack of resources. Then we ended up having to struggle with, okay, how do we maintain that jurisdiction? And I wanted to know, at this point, what we did was the judge exercised emergency jurisdiction, but that's not a long-term solution. So I was just wondering if there was anything in there that kind of gave some guidance as to how to handle those situations.
I can tell you just from not IFPA yet, but when that requirement, if a child is placed out of a preferred placement, the department, the way it's been handled within ICWA court is allowing the tribes to continue to be a part of ensuring that the services that are provided to a child, that they're included. And this is the reality, in that, like for medically fragile kids, those services for a child on the reservation aren't there. And this is where the department and the tribe and all the parties are able to convene when the tribe is in the out of preferred placement. And I believe it was shared, not here, but the department does have the reference as the pigs, where they talk about convening every 30 days on a child who is in out of preferred placement. As to your question, is there any guidance within IFPA that we are, not that I know of particularly.
Okay, thank you. Like I said, it's just a matter, like you mentioned, there's a situation where you have a child who needs the extra care or whatever that is not available on the reservation, even though the tribe should have exclusive jurisdiction in that matter. So I just want to make sure that we can properly care for these children as requested by the tribe, but actually have jurisdiction to do so in a longer term sense. So that was my sort of the purpose of my question. And thank you.
Thank you.
All right, Allison, just real quick, if I'm understanding your question, I think it might be section 7D. I think you mentioned if the tribe declines jurisdiction. If the tribe declines jurisdiction, then the state court would have jurisdiction. However, there's still that right to transfer back to tribal court. That doesn't go away. That parents, guardians, and the tribe would have. So even if they didn't accept jurisdiction at the beginning, they could still move for transfer back to tribal court later on in the case.
So is the exclusive jurisdiction piece in ICWA as it relates to children domiciled on the reservation, is that now discretionary as opposed to exclusive?
No, if a child's domiciled on the reservation, tribal jurisdiction is exclusive still.
Okay, and that's the scenario I'm talking about.
Okay, yeah, the tribe would still have exclusive jurisdiction.
And they choose not to exercise that. That's where, because they want the child to have access to services that cannot be provided by the tribe. They can only be provided by the state. Again, this is just about making sure that we are able to do right by the tribe while still having the legal ability to do so.
Okay, right. So in that case, the tribe can decline jurisdiction. But it's up to the tribe.
And one of the things that I have seen in a similar circumstance situation that I have is, though the tribe doesn't take exclusive jurisdiction, again, these meetings, they are able to come up with solutions in finding, in remedying the resource issue. And once that resource issue is resolved, then the tribe, always stating that we want to eventually take jurisdiction. I've seen that scenario play out. They just don't want to, just because they have a right to, they don't want to take the child for those reasons of lack of resources that the child needs, which are crucial for really the child's survival. And I'm speaking more particularly to like medical needs that won't be available on the tribe. But once those solutions are resolved, then a tribe saying then, okay, it would be in the child's best interest for us to take jurisdiction, and things are set up to where it's possible now.
And I wonder, Allison, are the parents objecting to the department or the tribe's intervention?
To be clear, it's not a matter of intervention. It is that we actually, in one case, we had a full trial as to whether the child was actually domiciled on the reservation and just happened to be in Albuquerque. That was the case that was determined. The parent in that particular case was absent. And the other two where I've dealt with similar situations, the parents did not take a position.
Okay. And I'm sorry, I probably shouldn't have used the term intervention. I guess I'm wondering, are the parents objecting to the fact that CYFD is taking custody or filed the case against them?
They objected to the child coming to
Yeah.
custody at all, but the issue was not related to the jurisdictional piece over who has the child in their court.
Does anybody have any other questions or comments about anything that we've talked about?
So Therese, I'll check the chat real quick, but in the meantime, if you could just also summarize super quick, you or Austin, the upcoming 2 trainings and
Sure.
how they relate.
Sure, thank you. Yeah, so we've posted them here. So next Thursday at noon, we're going to have sort of a deeper dive, a more in-depth look at both the active efforts provisions and the placement preferences. So we'll go into a little bit more detail on what IFPA requires on those. And then the following Thursday, we're going to have a more in-depth conversation about both working with tribes and pueblos and the qualified expert witness provision. For the Thursday, June 30th, Kip Bobroff, who's the general counsel for the Pueblo of Laguna, and Tracy Zamora, who's the ICWA liaison for the Pueblo of Laguna, will be very active in those sessions. And as I said earlier, there's going to be a lot of sort of figuring this out as we go along. So we're going to be trying to stick pretty closely to the statutory language and integrating it with both current case law in New Mexico and any sort of guidance that we can find from other jurisdictions. But we're going to try not to hypothesize too much. Those sessions will both be 1 hour each. So it's just going to be at that noon hour. We were thinking that a lot of times those seem to work best for all of us. So hopefully that's right. Sherry, please go ahead.
Oh, sorry, I was reading the chat. So I know that there exists a bench card that judges use in ICWA. Is there going to be another one issued for IFPA, or more just a comparison, or in addition to ICWA, this must be, or something both for the bench and for us, quite frankly, or let us use the bench card, you know, because there's a lot of changes here and it's going into effect now nearly. So I'm hopeful that somebody can throw something like that together, someone who really would like to get it right.
Well, I hope you find it helpful, Sherry. But one of the things that we've developed at the Law Center is, I think it's too extensive to be called a bench card, so we're still trying to sort of work on something that's a little bit handier. But one of the things we've developed is sort of a crosswalk. So we have ICWA, IFPA, and the Children's Code. And so we'll circulate that along with the presentation so that people will have access to both. And hopefully you'll find it helpful. And if you don't, or if you have any suggestions on how we can make it a little bit more accessible, please let us know. Because we're, so as I said, we're doing exclusively ICWA cases here in San Juan County and primarily ICWA cases in McKinley County. I know that Christy is in ICWA court. And so we really want to make sure we get it right. I don't know what other people's practices with regard to ICWA. I don't know if you have 1 case a year or 50 cases a year, but we'd love to work with everybody else to make sure that we're all getting it correct and develop resources that are helpful and easy to use.
And another county that has a lot is Cibola.
Mhm.
Don't forget Cibola.
Yeah.
Okay.
And Therese, I'll chime in that if I get my hands on a bench card, I will definitely be sending it out to everyone or any versions of bench cards because I know there's quite a few different trainings happening. So I will be trying to forward anything I get my hands on. And I also, before we lose everybody, Therese, I just want to thank your entire presenter group very much for this. I very much appreciate the time and putting it together for us. And I look forward to the upcoming 2 sessions, and I believe those are 1 hour each.
Yeah, it'll be just at that noon hour next Thursday and the following Thursday.
And I had several private chats asking me about CLE credit. Because of timelines, I wasn't going to be able to get pre-approval. I will work with the presenters. Therese, mainly I'll be bugging you to see if I can get any retro approval. That's why signing in into the chat is so important, because if I get any approval for a CLE credit, I'm going to have to be able to document your attendance, and that's the only way. But no promises, but I will see what Therese and I can come up with.
And besides a bench card, checklists work real well too. So just a suggestion.
All right. Thank you, Sherry.
Okay.
Thank you, everyone.
Yeah, we really appreciate everybody taking time on a Friday to attend. I don't know if it's a good thing or a bad thing that we're finished 5 minutes early, but I hope everybody's okay with that. We also have on the slides that you'll be receiving, there's contact information for everybody who is involved in putting this together. I think, as I said, we're all going to be working together to sort of figure this out and talk it through. But please feel free to reach out to any of us if you need some help with that talking through piece. We'd be happy to help out with that.
And I know I have at least, or had at least one of the appellate attorneys on. Nancy, I don't know if you could throw your, if you already didn't throw your email in chat. I don't know what your, what would you say, time cycles are right now for responding to questions. But I know in the past, you've been willing to help people with potential appellate issues. I don't know if you want to go off mute and chime in. We may have already lost her. Any questions anybody comes up with after the fact, if you email them to me, I can forward them. Or on the slide, Therese, you put the email addresses, so I assume they can email directly to you.
Yes, no problem.
Okay. If there aren't any other questions, I will stop the recording. And I think that lets us free for the day.
Terrific. I hope everybody has a great weekend.
Yes.